Good. All right, today I'm going to talk about the United States Constitution, the First Amendment. And last time I covered the freedom of religion. So this will be part two of the First Amendment, covering the other rights mentioned in the First Amendment. So the First Amendment reads, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or of the right of the people to peaceably assemble and to petition the government for a redress of grievances. So when I use brown text, that's a direct quote from the document. So the five freedoms protected by the First Amendment are the freedom of religion, freedom of speech, freedom of press, freedom of assembly, and the freedom to petition the government to correct grievances. So we talked about freedom of religion last time, so we'll talk about the remaining four this time. So freedom of the press we'll talk about first. Congress shall make no law abridging the freedom of speech or of the press. So speech and press are kind of two freedoms that go together because speech is spoken communication and press is written communication. So often the two are kind of paired or considered kind of two aspects of the same freedom. So a lot of things that apply to one also apply to the other. We'll look a little at the historical context. The First Continental Congress in 1774 wrote in an appeal to the inhabitants of Quebec. I think they were trying to get Quebec to join us in rebelling against the British because we were all British colonies at that point. And they wrote, the last right we shall mention regards the freedom of the press. The importance of this consists, besides the advancement of truth, science, morality, and the arts in general, in its diffusion of liberal sentiments on the administration of government, its ready communication of these thoughts between subjects, and its consequential promotion of union among them, whereby oppressive officers are shamed or intimidated into more honorable and just modes of conducting affairs. So they're giving a number of reasons why freedom of the press is important. That it's for advancing truth, as we heard in the previous speaker say. Also for other matters, science, morality, the arts, all of life basically, and also encouraging people in liberal sentiments on the administration of government, basically promoting freedom and promoting communication of thoughts between subjects. This is how people communicate. Speech often is maybe a more local thing, but press can be disseminated more widely. So it's a means of disseminating thoughts between people more widely, and also for promoting union among them, so that people can join together and convince each other to join in a cause. And I thought this last part was interesting, whereby oppressive officers are shamed or intimidated into more honorable and just modes of conducting affairs. So it's kind of admitting that these oppressive officers, they're behaving badly, but maybe by shame or intimidation we can make them more honorable and just in how they conduct themselves. Even if it doesn't change them internally, it might make their actions better. So I thought this is applicable today as school boards are complaining about parents threatening them. Here, the First Continental Congress was saying that officers should be shamed or intimidated into more honorable and just modes of conducting affairs. So we certainly have the right and indeed obligation to harangue our officials to conduct the affairs more honorably. In the founding era, there were not many court cases about freedom of the press, but the most well-known law related to this was the Alien and Sedition Acts, which made it illegal to publish any false, scandalous, and malicious writing against the United States government or the laws of the United States. So John Marshall, who was in Congress at the time, but soon became the Chief Justice of the Supreme Court, argued that freedom of the press only prevented prior restraint on what was published, but after publishing, it could be subject to criminal punishment. So this was the view from English common law, that the government farther back, the government had required license before you could print something. So that was a prior restraint on what was published. Um, but they allowed punishment of what was published after the fact. However, James Madison, who later became president, but was in Congress at this point as well, argued that inflicting punishment afterwards on what was published would have the same effect as prior restraint. So he was saying it really makes no difference if you prohibit it from being published or afterwards you punish someone for publishing something. It has the same effect. So he argued that you shouldn't punish afterwards either. And these laws expired in 1801, so they didn't end up being challenged in court. So it was never struck down in a court case, although there are later court cases that likely would have if these laws were still in effect. In 1995, there was a case called McIntyre versus the Ohio Elections Commission. And it's kind of interesting in that you have two originalists on the Supreme Court who want to look back at the original meaning. As we heard earlier, the Constitution is not a living document. It means, what it originally meant, it still means today. And so, doesn't matter. So they want to look back at what the original meaning was and to see, you know, what it meant originally, they say should be how we interpret and apply it today as well. So Clarence Thomas saw that anonymous political speech was commonly used, such as in the Federalist Papers, which argued for the ratification of the Constitution. They had been published anonymously. Later, we learned who was publishing them. John Jay and Alexander Hamilton and James Madison, but when they were originally published, they were published anonymously. So Clarence Thomas said, since the founders themselves, who wrote the Constitution and argued for its passage, used anonymous political speech, that they would have considered it protected. Antonin Scalia, who's also an originalist, said that frequent use did not prove that it was a protected right, that maybe even though they used it, it might not have been a right that they considered protected. So even people that are judges that are looking back at the original meaning can come to different conclusions on things. One thing that is illegal, is punishable, is freedom, even though we have freedom of the press, is libel. So if you make false or defamatory statements about someone, that's not protected. They can sue the publisher for libel. If they make false statements that defame, that tear down someone's reputation. So freedom of speech today is generally governed according to these guidelines that the courts have developed. It applies to government actions, but not private. So the government can't restrict your speech, but private parties are able to. Like an employer might say that you can't say certain things while you're doing your job. It applies to all levels of government, federal, state, and local. So this originally, the Bill of Rights applied to the national government, but through the 14th Amendment, it also applies to state and local governments as well. Not just the First Amendment, but the whole Bill of Rights. Also, that it applies to all speakers and writers, regardless of their medium or employers. So everyone has the freedom of speech and the freedom of the press. You don't have to be employed by a newspaper or a television station or a radio station to have freedom of the press. We all have freedom of the press. And it doesn't matter how you get your message out, whether you're printing it or putting it on the internet or yelling it on the street corner. Everyone has the freedom of the press and the freedom to write or speak, whatever your beliefs and ideas are. It also applies to expressive conduct, such as waving the flag or burning a flag, which, although you may not be actually speaking, you're essentially making your viewpoint known through your action. So expressive conduct like that is also considered a form of speech. And also to conduct necessary to speak effectively, like buying a public address system so you can be heard when you're speaking on the street corner, or buying advertising to get your message out, or spending money for political messages to get them out. So that also is considered necessary to express your freedom of speech. It covers also not just political speech, but any other topic as well, whether it be religion, science, morality, social conditions, daily life, arts, entertainment. Um, so it's not only political speech, although that certainly is an important one that should be protected because we can speak out against the government. But all topics are covered, and it's not only one uh, area where people get into court cases is, you know, is this speech, it's not only high speech, like talking about lofty ideals, but it can also be low speech, talking about, things that are not considered proper. Um, so there's often cases about obscenity, and can this be banned because it's obscene, or is that considered freedom of speech? So there are technical rules the courts have written about obscenity, but largely it's a very broad area of things we can talk about. And it applies to any and all ideas, not just acceptable opinions. You know, you don't need protection if your opinion is acceptable and everybody says, "Oh, yay, that's a great thing to say." You don't need protection against that. But you do need protection against things that are not considered acceptable or not generally popular opinions. So particularly important in our freedom of speech is that it applies to any and all ideas. So, you can we don't restrict what ideas people can talk about. People can talk about you know whatever their beliefs are, and we expect the marketplace of ideas, people to debate and to argue back and forth, and we accept that people will make a reasonable decision based on hearing all possible ideas and the arguments for and against them, and that they'll on their own reject bad ideas, that the government doesn't have to protect us against bad ideas. So on these grounds, there shouldn't really be anything such as hate speech, because all speech should be acceptable. And you should just argue against the ideas represented by someone if you don't agree with them. Argue that these are bad ideas, that people shouldn't believe in that, but not have the government shut people down because their opinion isn't acceptable. So governments can regulate the time, place, and manner of speech, but must do so in a content neutral way. Um, so, you can say, all right, we don't allow, noisy things to go on in the middle of the night because that disturbs people's sleep. But during the day, it's okay. Or regulating, say parades taking place um, to help promote, the public safety and people's freedom of movement. So that certain regulations can be placed on how people are speaking, the time, the place, and the manner, but it can't be based on the content. Can't be saying, well, you can have a parade because we like what you're saying, but this other group can't because we don't like them. That would be not content neutral. So, and it must not overly burden the speech or use too broad or vague restrictions. So laws have to be crafted specifically and not over broadly. Campaign finance is also an issue that comes up under freedom of speech. So the Supreme Court has upheld limits on an individual's contributions to a politician's campaign on the grounds that if you give too much to any one politician, it could be seen as corruption, as a way of bribing that politician. But it's rejected limits on a candidate's expenditures or on how much of their own money the candidate can spend. Because a person spending money on their own behalf to promote their candidacy is speech. It's a way of getting their ideas out. And also, um, as they accept contributions and expend that money, that's also speech as they're running their political campaign. So, so campaign finance on individual contributions are limited, but the expenditures are not. Also, there have been limits on corporate contributions to campaigns, although the court also saw that there's a need for corporations to speak on political matters. So they were often largely limited to using political action committees to make political speech. But that's a rather cumbersome way to for a company to make a political statement. So these limitations were relaxed on in several right to life group cases where groups were incorporated solely for promoting political ideas. So there were right to life groups that incorporated, so they were a corporation, but they weren't a corporation in business to make money. They were in business, gathering contributions from donors to promote a certain political cause. And so the court recognized that this was a different case from a company that's in business to make money primarily and also wants to make a political statement on the side. So these nonprofit political corporations were allowed greater latitude. This also culminated in the Citizens United versus the FEC, the Federal Election Commission case in 2010, where a nonprofit corporation had made a film critical of Hillary Clinton and released it during the 2008 primary where she was running. So the Supreme Court ruled in favor of Citizens United and against the FEC that this was a prohibited use of a corporation speaking in a political campaign. So it said corporations were allowed to speak directly, not only through a political action committee, and they were not to be discriminated against due to differences in wealth. In earlier campaigns, they had said that just because someone has raised more money doesn't mean that their opponent needs to be subsidized more. So based on that, they said differences in wealth aren't a reason to discriminate or close down a person's right to freedom of speech. Freedom of assembly in the U.S. versus Cruikshank in 1876, the Supreme Court said that we have the right to peaceably assemble, and it's an attribute of national citizenship. It's inherent in a republican form of government to petition the government. So rights of freedom of assembly and freedom to petition the government have been linked as being somewhat related to each other. Also in Hague versus CIO in 1939, said the regulation of assemblies in streets and parks cannot take into account the comfort, convenience, peace, and good order, but it must not, in the guise of regulation, be abridged or denied. So, there can be reasonable limitations on how people meet and where they meet and such in streets and parks, but you have to be careful that you're not just saying, oh, we're regulating this and regulating that, and effectively you're abridging, you're or denying the very right. So derived from the freedom to assemble and to speak comes a right of expressive association. So where people can form a group to promote particular common values and viewpoints. So this was illustrated in a case, the Boy Scouts of America versus Dale in 2000, where the Boy Scouts, the court ruled that the Boy Scouts could exclude a homosexual scout leader because that conflicted with their view of being morally straight. So even if the prevailing opinion or the court's opinion might be otherwise, a group of people can come together and promote their own viewpoints. Doesn't have to be popular or even according to laws that have been passed, but they can promote their own viewpoint because we have the freedom to assemble and to speak what we believe. Also, there's no emergency exception to these rights. It just says these rights shall not be abridged. Thus, and Congress shall make no law against these rights. Thus, the restrictions on gatherings imposed in the pandemic lockdowns were a grave infringement on our right to assemble. Government said you can't meet for church, you can't meet for a wedding, you can't go to a concert, even saying you can't have more than so many people in your home. These are all um, abridgments of our right to freedom of assembly, and thus I think are unconstitutional. The final right here is the freedom to petition the government. So this right dates back to the king, the right to petition the king from the Magna Carta in 1215. So initially this was just for nobles, but by 1669, still a long time ago, this was expanded to all subjects. This was in Britain, of course. So the king and the parliament treated these petitions seriously, and much legislation resulted from the petitions. Even maybe most of the legislation Parliament passed started as a petition from some citizen. In 1641, the Massachusetts Body of Liberties contained an explicit right to petition. So this was a mere 21 years after Massachusetts was founded, and they had already understood the importance of this right to petition and had incorporated it in this Body of Liberties. The declarations and resolves of the First Continental Congress in 1774 stated that colonists have a right peaceably to assemble, consider of their grievances, and petition the king, and that they could not be punished for this exercising that right. So that gave this right more protection than freedom of speech. Freedom of speech was allowed, but like with libel laws, you could be brought to court if you were libeling somebody. But this freedom to petition explicitly said that you couldn't be punished by the king or the government, the parliament, for bringing a petition to them. So this gives the right to communicate to a government body, but it doesn't guarantee an answer or the granting of the request, just that you can bring your request to the government. Early on, Congress would include time to consider petitions and would answer them. Not necessarily granting them, but at least would write back an answer saying why they would or wouldn't grant that request. However, beginning in 1836, they started to let petitions about slavery or its abolition die on the table. I think from this we might get the term tabling resolution. So if you table a proposal in a legislature, that means to let it die. So here they would just let it sit on the table and not do anything with it. So John Quincy Adams, who after being president became a congressman, fought to end this gag rule against slavery petitions in 1844, and he successfully got them to get rid of the gag rule, but they still let these petitions die in committee. And today, Congress mostly treats them as a formality and takes no action. And the Supreme Court has said that suits in court are a form of petition, and basically that the right of petition is not more than the right to free speech. So through the Congress and Supreme Court's actions, they've kind of lessened this right that we have to petition the government, and kind of just said, well, it's not really more than your right to free speech. Although historically it did have more protection than the right to free speech. So I think that right has kind of been diminished by their recent action. So in conclusion, one of the great American contributions to the world are the freedoms included in our First Amendment. So the freedom of speech and press allow us to express our views both verbally and in written form. And these allow a very broad range of ideas and are only subject to certain narrow restrictions. So we shouldn't allow what's the prevailing opinion or the politically correct opinion to limit what our speech is. Our speech, we're allowed to say what we think, and we should speak out, as Mike was saying, and not be silenced by the prevailing opinions, because we have this precious freedom of speech. Also, the freedom of assembly and association allow us to gather and associate with whomever we please and to promote the views we hold in common. So if we hold views together, we should gather together and speak up and state those views and speak out, let people hear them, and try to convince people of our beliefs. And the freedom to petition the government allows us to voice concerns to our officials without any penalties. So if they're restricting people from speaking to school boards, say, as they seem to want to now, we should not allow that to happen because we have the right to petition the government officials and not to have any penalties because we do that. So